Okay, we have you can hear me?
Yeah,
Y'all can hear me?
yeah, I can hear you.
Oh,
Go
Yeah, we can
ahead.
hear you.
okay. Meaning of certain words in this act: will, real estate, personal, estate, number, gender. The words and expressions hereinafter mentioned, which in their ordinary wait, hold on a second. I can't see it. Let me blow this up a little bit more. The words and expressions hereinafter mentioned, which in their ordinary signification have a more confined or different meaning, shall in this act, except where the nature of the provisions or the context of the act shall exclude such construction, be interpreted as follows. That is to say, the word will shall extend to a testament, and to a condicile, and to an appointment by will or by writing in the nature of a will in exercise of a power, and also to an appointment by will of a guardian of a child, and also to an appointment by will of a representative under Section 4 of the Human Tissue Act of 2004, or Section 8 of the Human Transplantation Wales Act of 2013, and to any other testamentary disposition. And the words real estate shall extend to manors, advalsons, masuges, lands, tithes, rents, and hereditaments, whether corporeal, incorporeal, or personal, and to any undivided share thereof, and to any estate, right, or interest other than a chattel interest therein, and the words personal estate shall extend to leasehold estates and other chattels real, and also to monies, shares of government and other funds, securities for money, not being real estate, debts, choices in action, rights, credits, goods, and all other property whatsoever which by law devolves upon the executor or administrator, and to any share or interest therein. And every word importing the singular number only shall extend and be applied to several persons or things as well as one person or thing. And every word imported the masculine gender only shall extend to and be applied to a female as well as male. So let's go down to three. We have all property may be will, disposed of by will. Contingent interest, there you go, right there. Contingent interest, rights of entry, and property acquired after the execution of the will. It shall be lawful for every person to devise, bequest, or dispose of by his will, executed in manner herein after required, all real estate and all personal estate which he shall be entitled to either at law or in equity at the time of his death, and which, if not so devised, bequested, or disposed of, would devolve upon his executor or administrator, and the power hereby given shall extend to all contingent, executory, or other future interests in any real or personal estate, whether the testator may or may not be ascertained as the person or one of the persons in whom the same respectively may become vested, and whether he may be entitled thereto under the instrument by which the same respectively were created, or under any disposition thereof by deed or will, and also to all rights of entry or conditions broken, and other rights of entry, and also to such of the same estates, interest, and rights respectively, and other real and personal estate, as the testator may be entitled to at the time of his death, notwithstanding that he may become entitled to the same subsequently to the execution of his will. Oh, they got the words in here, boy. Okay, we got textual amendments. That was repealed. That was all repeals, repeals. No will of a person under age is valid. No will made by any person under the age of 18 shall be valid. All right. We got signed and attestation of wills. No will shall be valid unless it is in writing and signed by the testator or by some other person in his presence and by his direction. And it appears that the testator intended by his signature to give effect to the will, and the signature is made or acknowledged by the testator in the presence of two or more witnesses present at the same time. At the mouths of two or three, the matter is established. I think that's in Deuteronomy, if I'm not mistaken. And each witness either attests and signs the will or acknowledges his signature in the presence of the testator, but not necessarily in the presence of any other witness. But no form of attestation shall be necessary. For the purpose of paragraphs C and D of subsection 1, in relation to wills made on or after the 31st January 2020 and on or before 31st of January 2024, presence includes presence by means of video conference or other visual transmission. Oh, okay. You guys with me?
Yep.
Yep.
Okay.
Yes, I'm here.
Let's go to
I'm
10.
listening.
Appointments by will to be executed like other will, and to be valid, although other required solemnity are not observed. Okay. No appointment made by will in exercise of any power shall be valid unless the same be executed in manner herein before required. And every will executed in manner herein before required shall, so far as respects the execution and attestation thereof, be a valid execution of a power of appointment by will, notwithstanding it shall have been expressly required that a will made in exercise of such power should be executed with some additional or other form of execution or solemnity. Soldier and mariners wills except, provided always that any soldier being in actual military service, or any mariner or seaman being at sea, may dispose of his personal estate as he might have done before the making of this act. Okay, let's go down here. So we got modifications, not altered, textual amendments. So let's go down to 13. Stop. Publications of will not requisite. Every will executed in manner herein before required shall be valid without any other publication thereof. So you don't got to record this nowhere. Will not to be void on account of incompetency of attesting witness. If any person who shall attest the execution of a will shall, at the time of the execution thereof, or at any time afterwards, be incompetent to be admitted a witness to prove the execution thereof, such will shall not on that account be invalid. So even if you become incompetent after you attest to the will still stands. Gifts to an attesting witness to be void. If any person shall attest the execution of any will to whom or to whose wife or husband any beneficial devised legacy, estate, interest, gift, or appointment of or affecting any real or personal estate other than and accept charges and directions for the payment of any debts or debts shall be thereby given or made. Such devised legacy, estate, interest, gifts, or appointment shall, so far only as concerns such person attesting the execution of such will, or the wife or husband of such person, or any person claiming under such person or wife or husband, be utterly null and void, and such person so attesting shall be admitted as a witness to prove the execution of such will, or to prove the validity or invalidity thereof, notwithstanding such devices, legacy, estate, interest, gifts, or appointment mentioned in such will. Okay, modifications not altered. Creditor attesting to be admitted a witness. In case by any will, any real or personal estate shall be charged with any debt or debts, and any creditor or the wife or husband or civil partner of any creditor whose debt is so charged shall attest the execution of such will. Such creditor, notwithstanding such charge, shall be admitted a witness to prove the execution of such will, or to prove the validity or invalidity thereof. 17, we got the executor shall be admitted a witness. No person shall, on account of his being an executor of a will, be incompetent to be admitted a witness to prove the execution of such will, or a witness to prove the validity or invalidity thereof. We got 18. Wills to be revoked by marriage, except in certain cases. Subject to subsections 2, 5 below, a will shall be revoked by the testator's marriage. A disposition in a will in exercise, a disposition in a will in exercise of a power of appointment shall take effect, notwithstanding the testator's subsequent marriage, unless the property so appointed would, in default of appointment, pass to his personal representatives. Where it appears from a will that at the time it was made, the testator was expecting to be married to participate to a particular person, and that he intended that the will should not be revoked by the marriage. The will shall not be revoked by his marriage to that person. Where it appears from a will that at the time it was made, the testator was expecting to be married to a particular person, and that he intended that a disposition in the will should not be revoked by his marriage to that person. That disposition shall take effect notwithstanding the marriage, and any other disposition in the will shall take effect also, unless it appears from the will that the testator intended the disposition to be revoked by the marriage. Nothing in this section applies in the case of a marriage which results from A, the conversion of a civil partnership into a marriage under Section 9 of the Marriage Same-Sex Couples Act of 2013 and regulations made under that section. The conversion of a civil partnership into a marriage under Part 3 of the Marriage and Civil Partnership, Northern Ireland. Number 2, Regulation 2020. The conversion of a civil partnership into a marriage under Part 3 and 4 of the Marriage of Same-Sex Couples, where the civil partnership is a convertible North Ireland civil partnership as defined in Regulation 2 of those regulations, or the changing of civil partnership formed under Part 3 of the Civil Partnership Act into marriage under the Scotland Act, another Scotland Act, any order made under Section 104 of the Scotland Act of 1998. Okay. All right, let's go to 18A, effects of dissolution or annulment of marriage on wills. Where after a testator has made a will, a court or civil jurisdiction in England and Wales dissolves or annuls his marriage, or his marriage is dissolved or annulled, and the divorce or annulment is entitled to recognition in England and Wales by virtue of Part 2 of the Family Law of 1986. Provisions of the will appointing executors or trustees or conferring a power of appointment, if they appoint or confer the power on the former spouse, shall take effect as if the former spouse had died on the date on which the marriage is dissolved or annulled. And any property which or an interest in which is devised or bequested to the former spouse shall pass as if the former spouse had died on that date, except in so far as a contrary intention appears by the will. Subsection 1B above is without prejudice to any right of the former spouse to apply for financial provisions under the inheritance provisions or Family and Dependents Act of 1975. Okay. Now we got will to be revoked by civil partnership. Okay. They are heavy on the civil partnership in this one. Subsection subject to subsection 2, 6, and 7. A will is revoked by the formation of a civil partnership between the testator and another person. A disposition in a will in exercise of a power of appointment takes effect despite the formation of a subsequent civil partnership between the testator and another person, unless the property so appointed would, in default of appointment, pass to the testator's personal representative. If it appears from a will that at the time it was made, the testator was expecting to form a civil partnership with a particular person, and that he intended that the will should not be revoked by the formation of the civil partnership, the will is not revoked by its formation. Subsections 5 and 6 apply if it appears from a will that at the time it was made, the testator was expecting to form a civil partnership with a particular person, and that he intended that a disposition in the will should not be revoked by the formation of the civil partnership. The disposition takes effect despite the formation of the civil partnership. Any other disposition in the will also takes effect unless it appears from the will that the testator intended the disposition to be revoked by the formation of a civil partnership. Nothing in this section applies in the case of a civil partnership which results from the conversion of a marriage into a civil partnership under Part 3, 4, or 5 of the Marriage and Civil Partnership Regulations of Northern Ireland. Okie dokie. Number 18C is effect of dissolution or annulment of civil partnership on wills. Okay. They are heavy on the civil partnerships. This
Got a
section
story about that.
Okay. This section applies if, after a testator has made a will, a court of civil jurisdiction in England and Wales dissolves his civil partnership or makes a nullity order in respect of it, or his civil partnership is dissolved or annulled, and the dissolution or annulment is entitled to recognition in England and Wales by virtue of Chapter 3 of Part 5 of the Civil Partnership Act of 2004. Except in so far as a contrary intention appears by the will, provisions of the will appointing executors or trustees or conferring a power of appointment, if they appoint or confer the power on the former civil partner, take effect as if the former civil partner had died on the date on which the civil partnership is dissolved or annulled. And any property which or an interest in which is devised or requested to the former civil partner shall pass as if the former civil partner had died on that date. Subsection 2B does not affect any right of the former civil partner to apply for financial provisions under the Inheritance Provisions of Family Independence Act of 1975. Effects on subsiding will of conversion of civil partnership into marriage. The conversion of a civil partnership into a marriage does not revoke any will made by any party to the civil partnership before the conversion or affect any disposition in such a will. The conversion of a civil partnership into a marriage does not affect any previous applications of Section 18B2 to 6 to a will made by a party to a civil partnership before the conversion or disposition in such a will. Subsections 1 and 2 are subject to subsection 4. And subsection 4 says any reference in a will to a civil partnership or civil partners, however expressed, is to be read in relation to any civil partnership that has been converted into a marriage, or civil partnership partners who have converted their civil partnership into a marriage as referring to that marriage or married couple as appropriate. Subsection 4 is subject to any contrary intention appearing from the will. 6, in this section, conversion means the conversion of a civil partnership into a marriage under Section 9 of the Marriage Act, Same-Sex Couples Act of 2013, and regulations made under that section. The conversion of a civil partnership into a marriage under Part 3 of the Marriage and Civil Partnership Northern Ireland, number 2, Regulation 2020. The conversion of a civil partnership into a marriage under Part 3 or 4 of the Marriage of Same-Sex Couples Conversion of Civil Partnership Regulations of 2014, where the civil partnership is a convertible Northern Ireland civil partnership as defined by Regulation 2 of those regulations. All right, regulations. Uh, the changing of a civil partnership formed under Part 3 of the Civil Partnership Act of 2004 into a marriage under the Marriage Act of 1977 for Scotland, the Marriage and Civil Partnership Act of 2014 of Scotland, or any order made under Section 104 of the Scotland Act 1998 in consequence of the Marriage and Civil Partnership Scotland Act of 2014, converted is to be read accordingly. Okay, so the effect on subsiding will of conversion of marriage into a civil part. Jeez, I just felt like I just read this already. Okay. The conversion of a marriage into a civil partnership does not revoke any will made by a party to the marriage before the conversion, or affect any disposition in such a will. The conversion of a marriage into a civil partnership does not affect any previous application of Section 18(2) to 4(2), a will made by a party to the marriage before the conversion, or a disposition in such a will. Subsections 1 and 2 are subject to subsection 4. And subsection 4, any reference in a will to a marriage or spouse, howsoever expressed, is to be read in relation to any marriage that has been converted into a civil partnership, or married couple who have converted their marriage into a civil partnership as referring to that civil partnership or the parties to it as appropriate. Subsection 4 is subject to any contrary intention appearing from the will. In this section, conversion means the conversion of a marriage into a civil partnership. Okay, they're going backwards now. So first it was the conversion into the civil partnership into a marriage. Now it's marriage into civil partnership under Part 3 of the Marriage and Civil Partnership Act, I believe, of Northern Ireland. The conversion of a marriage into a civil partnership under Part 4 or 5 of those regulations, and converted is to be read accordingly. Okay, no will to be revoked by presumption. No will shall be revoked by any presumption or an intention on the ground of an alteration in circumstances. No will to be revoked but by another will or codicil, or by a writing executed like a will, or by destruction. No will or codicil or any part thereof shall be revoked otherwise than as aforesaid, or by another will or codicil executed in manner herein before required, or by some writing declaring an intention to revoke the same, and executed in the which a will is herein before required to be executed, or by the burning, tearing, or otherwise destroying the same by the testator, or by some person in his presence and by his direction, with the intention of revoking the same. No alterations in a will shall have any effect unless executed as a will. So basically, you got to rewrite the whole will if you want to change anything to it. That's what I'm getting. No, where we at? Okay. Okay. Now, no obligatory interlineation or other alteration made in any will after the execution thereof shall be valid or have any effect, except so far as the words or effects of the will before such alterations shall not be apparent, unless such alterations shall be executed in like manner as herein before is required for the execution of the will, but the will with such alterations as part thereof shall be deemed to be duly executed if the signature of the testator and the subscription of the witnesses be made in the margin or on some other part of the will opposite or near to such alterations, or at the foot or end of or opposite to a memorandum referring to such alterations and written at the end or some other part of the will. Okay. You got to re-sign if you do alter it. No will revoked to be revived otherwise than by re-execution or a codicil to revive it. No will or codicil or any part thereof which shall be in any manner revoked shall be revived otherwise than by the re-execution thereof or by a codicil executed in manner herein before required and showing an intention to revive the same. And when any will or codicil which shall be partly revoked and afterwards wholly revoked shall be revived, such revival shall not extend to so much thereof as shall have been revoked before the revocation of the whole thereof, unless an intention to the contrary shall be shown. A devise not to be rendered inoperative by any subsequent conveyance or act. So no conveyance or other act made or done subsequently to the execution of a will or relating to any real or personal estate therein comprised, except an act by which such will shall be revoked as aforesaid, shall prevent the operation of the will with respect to such estate or interest in such real or personal estate as the testator shall have power to dispose of by will at the time of his death. A will shall be construed to speak from the death of the testator. Every will shall be construed with reference to the real estate and personal estate comprised in it to speak and take effect as if it had been executed immediately before the death of the testator, unless a contrary intention shall appear by the will. Okay, we got residuary devise shall include estates comprised in lapsed or void devices. Unless a contrary intention shall appear by the will, such real estate or interest therein as shall be comprised or intended to be comprised in any device in such will contained, which shall fail or be void by reason of the death of the devisee in the lifetime of the testator, or by reason of such device being contrary to law or otherwise incapable of taking effect, shall be included in the residuary device, if any, contained in such will. Oh, excuse me. A general device of the testator's lands shall include copyhold and leasehold as well as freehold lands. A device of land of the land of the testator, or the land of the testator in any place or in the occupation of any person mentioned in his will, or otherwise described in a general manner, and any other general device which would describe a leasehold estate, if the testator had no freehold estate which could be described by it, shall be construed to include the leasehold estates of the testator, or his leasehold estates, or any of them to which such description shall extend, as the case may be, as well as freehold estates, unless a contrary intention shall appear in the will. So it don't matter which ones you got: lease, land. A general gift shall include estates over which the testator has a general power of appointment. A general device of the real estate of the testator, or of the real estate of the testator in any place or in the occupation of any person mentioned in his will, or otherwise described a general manner shall be construed to include any real estate or any real estate to which such descriptions shall extend as the case may be, which he may have power to appoint in any manner he may think proper, and shall operate as an execution of such power, unless a contrary intention shall appear by the will. And in like manner, a bequest of the personal estate of the testator or any bequest of personal property described in a general manner shall be construed to include any personal estate or any personal estate to which such description shall extend, as the case may be, which he may have power to appoint in any manner he may think proper, and shall operate as an execution of such power, unless contrary intention shall appear by the will. A device without any words of limitation shall be construed to pass as free. Where any real estate shall be devised to any person without any words of limitation, such devised shall be construed to pass the fee simple or other whole estate or interest which the testator had power to dispose of by will in such real estate, unless a contrary intention shall appear by the will. The words die without issue or die without leaving issue shall be construed to mean die without issue, living at the death. Wow. Okay. In any device or bequest of real or personal estate, the words die without issue or die without leaving issue or have no issue or any other words which may import either a want or failure of issue of any person in his lifetime or at the time of his death, or an indefinite failure of his issue, shall be construed to mean a want or failure of issue in the lifetime or at the time of his death, of the death of such person, and not an indefinite failure of his issue, unless a contrary intention shall appear by the will. By reason of such person having a prior estate tail, or of a uh, presidenting, uh, presidenting, am I saying that right? I don't think I'm saying that right. Precedenting gift, being without any implication arising from such words. A limitation of an estate tail
John,
to, yes.
that's proceeding.
Proceed. Yeah, I knew I was saying it right. I was looking at, I'm gonna start this line over right here where I was at. Yeah,
Okay.
because I can't read like that. I got to start over. Okay, I'm gonna just start over. In any device or bequest of real or personal estate, the words die without issue or die without leaving issue or have no issue or any other words which may import either a want or failure of issue of any person in his lifetime or at the time of his death, or there's a lot of ors in here, an indefinite failure of his issue shall be construed to mean a want or failure of issue in the lifetime or at the time of the death of such person, and not an indefinite failure of his issue, unless a contrary intention shall appear by the will, by reason of such person having a prior estate tail or of a preceding gift. Being without any implication arising from such words. A limitation of an estate tail to such person or issue or otherwise, provided that this act shall not extend to cases where such words are as aforesaid import, if no issue described in a preceding gift shall be born, or if there shall be no issue, who shall live to attain the age or otherwise answer the description required for obtaining a vested estate by a preceding gift to such issues. See, the way they got that written out right there, that is something going on there. I got to read that over. This is just a lot going on. No device to trustees or executors, except for a term or a presentation to a church, shall pass as chattel interest. Where any real estate other than or not being a presentation to a church, so where any real estate shall be devised to any trustee or executor, such devices shall be construed to pass the fee simple or other the whole estate or interest which the testator had power to dispose of by will in such real estate, unless a definite term of years, absolute or determinable, or an estate of freehold, shall thereby be given to him expressly or by implication. Trustee under an unlimited device, where the trust may endure beyond the life of a person beneficially entitled for life, shall take the fee. Where any real estate shall be devised to a trustee without any express limitation of the estate to be taken by such trustee, and the beneficial interest in such real estate or in surplus rents or profits thereof shall not be given to any person for life, or such beneficial interest shall be given to any person for life. But the purpose of the trust may continue beyond the life of such person. Such device shall be construed to vest in such trustee the fee simple, or other whole legal estate which the testator had power to dispose of by will in such real estate, and not an estate determinable when the purpose of the trust shall be satisfied. Okay. That's why we got to put the trust together between the Declaration of Independence and the will. Um, Gifts to children or other who leave issue living at the testator's death shall not lapse. Where a will contains a device or bequest to a child or remoter descendant of the testator, and the intended beneficiary dies before the testator, leaving issue. And issue of the intended beneficiary are living at the testator's death. Then, unless a contrary intention appears by the will, the device or bequest shall take effect as a device or bequest to the issue living at the testator's death. Living at the testator's death. Okay. Where a will contains a device or bequest to a class of persons consisting of children or remoter descendant of the testator, and a member of the class dies before the testator, leaving issue, and issue of that member are living at the testator's death. Then, unless a contrary intention appears by the will, the device or bequest shall take effect as if the class included the issue of its deceased members living at the testator's death. Issue shall take under this section. Issue shall take under this section through all degrees according to their stock in equal share, if more than one, any gift or shares which their parent would have taken, and so that no issue shall take whose parent is living at the testator's death and so capable of taking. For the purpose of this section, the illegitimacy of any person is to be disregarded, and a person conceived before the testator's death and born living thereafter is to be taken to have been living at the testator's death. Okay. Where we at? Modifications. Did I pass anything? Okay. Textual amendments. Administrative justice. All right. Okay, disclaimer or forfeiture of gift. This section applies where a will contains a device or bequest to a person who disclaims it or has been precluded by a forfeiture rule from acquiring it. The person is, unless a contrary intention appears by the will, to be treated for the purpose of this act as having died immediately before the testator. Damn, they gonna kill you before you even get your stuff. But in the case within subsection 1B, subsection 2 does not affect the power conferred by section 2 of the Forfeiture Act of 1982, power of court to modify the forfeiture rule. In this section, the forfeiture rule has the same meaning as in the Forfeiture Act of 1982. Ooh, excuse me. Okay. Act not to intend to wills made before 1838, nor to estate pure or of persons who died before 1838. This act shall not extend to any will made before first day of January 1838, and every will re-executed or republished or revived by any codicil, shall, for the purpose of this act, be deemed to have been made at the time at which the same shall be so executed, republished, or revived. And this act shall not extend to any estate per RV
Who author
of
V?
any who?
Who author V?
Oh, that's like French pro auto vid. Okay. So pro auto vid of any person who shall die before the first day of January 1838. And that's it.
All right, good job, John. I'll
Word.
name you the natural reader.
Aha. No, sir.
There's apps. There's companies they will pay you to use your voice.
There were, what'd you say?
There's companies with for an AI to use your voice. They'll pay
Oh
you
yeah.
for it.
Yeah.
Yeah.
Now I got Mateo on my phone. He can't get onto the Zoom because he doesn't have his phone. So he's listening. He can hear us.
Oh, okay. Peace, Mateo. What's the word?
Hey, brothers, I can hear y'all. You sound very clear too, brother.
That's what's up. I appreciate that. I meant to call you back yesterday, man, but we hit Walmart, ShopRite, and BJ's. It was a lot going on.
Hold your ears, women. That's what they do too.
Man, we done listen. We done dragged the kids with us and everything. So it was a whole event.
Right.
So who's gonna take a first crack at the understanding this Wills Act?
Well, one thing I want to share. Hold on. Can I mute this? Ooh. Hello. Okay. Why it was so heavy on the marriage part.
Mm-hmm.
When my father passed away, it was really important for us to find his will because he was still married at the time, but he was separated from his wife. So that means the wife wasn't close with the family. And by that meaning that she's still legally married to him. So she will inherit his stuff and not his kids. So when we was trying to find a will and when spirit led me to the will, oh spirit, gave it to the sister and gave it to the people that was helping us with our legal stuff. They came back and said that she's an omitted spouse, meaning the time that my dad created the will, he quote unquote omitted her, but he should have redid it when he remarried. So that's why they heavy on that marriage because the spouse can claim everything and leave the kids out of the door. But it's until it is clearly said, expressed in the will or otherwise, then that's when things get, dispersed correctly.
Okay. That's definitely good. So this will the intention has to be full to put this will together.
Mm-hmm.
Okay.
So who you gonna get married to?
But yeah, you trying to start a fight.
Oh, the Bible tell you who's supposed to be your bridegroom. It's the Lord.
That's right.
Ladies, close your ears. Ladies, close your ears. They're supposed to marry the Lord too. You gotta marry the Lord too. That's what the Bible is saying. You marry no other but it first before you go off and marry man or woman. You're right. Marry the Lord first. Nobody ain't having that. Inheritance will never be taken away from you. You're exactly right.
Yep.
But nobody ain't having that though.
I'm
Oh man.
well, running down to City Hall to get married is submitted to somebody else anyway.
Right, you submit it to
Yeah.
man, you submit to the Lord.
Mm-hmm.
So you can draw this stuff up yourself
Yourself. Mm-hmm.
and file it in miscellaneous.
Nice.
And still get the same recognition.
Sookie.
I'll have
Okay.
to show y'all that I drew up my daughter's birth certificate and filed it.
Oh, nice. Okay.
Mateo, you still have your will
Yeah,
around you?
want me to read it?
Yeah, read it for us.
Y'all doing too much. Y'all not supposed to be reading.
I just did. I just
Y'all
read
just
15
read the
pages.
whole Wills Act.
Yeah, you read the
Just
whole
read
will
15.
that.
Well, send it to
Mateo,
me. I'll read it.
yours is nice and sweet. You'll be reading for about a good 1 minute,
I
maybe
think
two.
it's just beautiful to hear somebody else talking.
Well, send it to me. I'll read it right now.
It won't let me scan it. I gotta redo
Oh,
my thing. My
oh,
stuff
okay.
won't be.
Go on and yeah.
There's two things that I want to show y'all
hmm
of how I gave notice to the Postmaster General on legal paper of notice of the estate, and I'm taking the office of it.
hmm
That's one. And that comes in the form of an executive letter. Okay. And I used myself as the foreign postmaster. And all I did is the way I constructed it and show where I reside at now. I reside on the Ferdinand property and did everything. And I took it in, gave him a copy, and he stamped my copy and registered.
Hmm.
Okay. But the will goes like this. It says, in the name of the will and testament of Mateo F. Ramos Estate. Dated July 1st, 2013. In the name of the one true divine creator and grantor of all free will, all existence, all laws, all life, and all property and rights. I, Mateo F. Ramos Estate, originally born at the geographical place also known as Queens, New York, now living in the geographical place also known as Atlanta, Georgia. And being of the age and sound mind, do make, ordain, and declare this instrument to be public record of the express of my will, revoking all prior wills and promises. First, let it be known to all whom these presents come, with the divine creator as my witness, and with those who acknowledge this instrument by their testament, I hereby affirm that the instrument is to be known as my one, only, and true last will and testament. Express accurately my intentions and purpose, written clearly at my discretion, and signed and sealed freely by my own hand. Second, to ensure the proper and lawful administration of my estate, the satisfaction of all debts and obligations, and disposal of all gifts, grants, and bequests, I hereby appoint a general executor and guardian, hereafter named as sovereign over my entire known and unknown estate, and the rule of succession for the appointment of lessers executors and their ministers as fiduciaries. Third, all property, rights, device created by the estate, the existence of my estate, in the name of the estate, or administrated on the behalf of the estate must first be properly identified and brought under the administration of the general executor and guardian before any discretions or disposal to the beneficiaries may commence. I hereby direct and empower the general executor and guardian to use all necessary authority and power to conduct a thoroughly tracing and accounting of all assets, property, rights, benefits, beneficiaries, trustees, securities, and negotiable instruments for the entire estate. Fourth, upon the proper completion of tracing and accounting of my entire estate, it is my first intention to ensure the continuing care and well-being of my family, kin, and heirs and censors. Fifth, in the nature of supplement rules for law and equity. That's your truth affidavit, y'all. In accordance with common law, justice, and the United States of America contracts, the Constitution. Six, I hereby give and grant, devise, and bequeath my entire estate according to the following article. And Article 1 starts off with the General Executor and Guardian. And that's where I say, I hereby announce, anoint, affirm, and entrust Mateo Ferdinand, being a man as General Executor and Guardian and sovereign over my entire estate. I can go on, y'all, but I'm not reading all of it. There's a whole lot of reading. But I'm going to make sure that I upload.
Okay.
That is peace, brother.
I'm going to change my setting on the thing because I wasn't paying attention. I got to change my setting to legal paper and upload it that way.
What's that? 8.5 by 14?
Yeah. All this stuff, your will got to be on legal paper. Your truth affidavit got to be on legal paper. Your trust certificate is got to be on regular 8 by 1/2 or whatever that is. So that's
8 by 11.
And a partial.
Repeat that last part again.
Your will and your truth affidavit looks like a letter. When you bring out your trust certificate and your IDs and all that, it looks like a partial.
Okay.
Mm-hmm.
But that's why I want y'all to understand the will, because it's God who's appointing you, who's anointing you, who's putting the Christ as your last name.
Indeed.
That's what we're deriving from the scriptures and them saying into the will.
Right. You don't have to put the scripture like
Well, yeah, not the scripture.
Have to be such and such, but the scripture itself is the power.
Mm-hmm. Yep.
And
I was doing
code. You don't have to place the code, it's what's inside the code. It's really the title of the code.
Mm-hmm.
Who sent that depot that's on the screen?
What you say?
Who's who put that
That's me.
depot?
That's me. I'm sharing my screen.
Yeah, we supposed to do something with that?
This is the certificate. This is the certificate that you're issuing from that describes the will and the Declaration of Independence. It's coming from this setup right here, this deed poll setup.
There you go, John. Now, read the title of the deed poll. Read it. What it say?
Change of name deed intended for enrolling in the central office of the senior courts of England and Wales. But you see the logo. Go ahead.
Don't worry about England and Wales and all that.
Right.
But what do it say? Change of name.
Yes, sir.
So those who gotta learn that you're doing nothing but change your status. You're gonna keep your name, you're just changing the status of it. And you appointing a new name. Your estate is the will appointing you as the general executive. Or in my case, as the ambassador. But everybody want to say executive because it says EX when you do certain things. It'll come back and say EX. But the most important thing about EX is that all these high titles have the authority to execute. That's what
we're doing the depot in like a format and not writing it out.
This format right here.
Yeah, that's
but not without the boxes and all that other stuff. But we're using the contents of this deed poll to structure our certificate. So you see how it says change of name. your new name in full, your address, your old name, status, nationality, section, um, all of these things, all of these are the parts that we're drawing from this document to create our own that represents the Declaration of Independence, Affidavit of Truth, and the will.
I got
So,
something else. I got something else that I want to share
okay.
along with that. Um, I'm putting it in the chat.
So see y'all, John know what John got it. He sees it. Mr. Norris sees it too, y'all. You have to, the Declaration of Independence says you got a right to alter or abolish. So you take their templates, they're showing you how to do it. So you alter the titles and you take them damn boxes off. And you put your information in them. And then instead of it showing England, Wales, who that would say, but your estate. That would be your symbol.
Here's the chat. Okay,
And you,
here's the chat.
instead of saying change your name, because the estate is the name, you would say change of status.
Then we can use the contents. Your new name, your old name.
There you go.
And then it gets really I keep losing the page. Hold up. This is where it gets interesting right here. Witness and it is hereby declared, right? I absolutely, I shall, I authorize, in witness. See that? Then
Hey
you have
John,
Yep.
go ahead.
I just sent something in the chat. Take a look at that. Oh no, not Telegram, but the Zoom. I can put it in the Telegram. Well, whichever's good for you.
Go to the chat, John. The Zoom chat.
That was a Word document.
Yeah, that was a Word document.
What was the name of it? I didn't
Hold
see the
on, let
name.
me put it. I'm gonna put it in Telegram for you.
Okay, because it's harder for me to pull it up from here.
Rob, what is it?
It's the ecclesiastical depot, but it's in words. Like I mean, it has. I'll show you.
Right, that QSIP is the depot. But I can't say the damn word, that 166.
Set that
Is
KB.
the depot.
Yeah.
Yeah, Sister KV. John,
So you use the depot to make your claim back.
right. John, take a look at that. It's in Telegram.
Hey, John, when you get a chance, read that 166 Act. And it'll help identify what that depot really is.
Okay, give me 1 second. Let me open this up real quick. Da-da-da-da-da. You guys can still see my screen?
Yeah.
Yeah.
Mm-hmm.
Okay, so this is the Ecclesiastic Depot, per curiam, dividend, we divine and mortal spirits expressed in trust to the living flesh known as blank of the blank family, hereby give life to this sacred irrevocable deed through our seal in blood and agreement to convey to the conveyance in terms pronounced therein. Number one, while we have expressed in trust our real property and will, and while no consent given nor protested otherwise made that such conveyance is lawful, we bring attention to our mistakes and facts by failing notice of our competent living status, and number two, as our actions and this instrument makes our status clear and temporary testamentary trust sets the KV derivative thereof formed upon such errors of presumptions as are abandoned loss, death, or incompetence must be immediately dissolved, including a full account provided to us without delay. Y'all stop that in that tub. Stop it. Number three, to ensure no further mistakes are made by any parties, we give full further notice that all acts in commerce or law we engage as surety of our trust blank and kindly ask you update your records. And number four, furthermore, we gratefully decline any offers of benefits from any and all estates which you and your colleagues administrate. As a result, any charges sent to us by mistake will be duly returned to you for discharge in accordance with law, and as we have given proper notice that we have caused any further injury, your acknowledgement that no further demands, debts, or actions shall be issued against us in claiming injury as surety to the property you administer. And number six, receipt of this deed poll is acknowledged and accepted. All
What you think
right.
about that?
No. Don't ask John what he think about it. What you think about it, bro?
I think that it's saying kind of like what we need to say, but we need to put our names and stuff on it.
Now, John,
Hmm?
I mean, bro, didn't he just go over that deed poll, the instrument?
Well, yes, he did. Yeah, what
On your strength.
he
See that
he
instrument on your
did.
strength? It say all of that, but very less, though.
Yes.
You guys looking at my screen?
Yeah.
We're looking at the screen.
This beyond this part right here, this is all that it says. You saying mostly the same stuff, but you see how it says I absolutely, I shall, I authorize, and witness. That's it.
About constantly understanding what you're doing. If you gotta say all of that, that means you don't constantly know what you're doing.
Gotta be broken down. Yeah.
What I mean by that, Rod, is the more you identify yourself with the word, the more you will be more conscious and confident in altering these templates.
Mm-hmm.
Because the power is already in the template.
Mm-hmm.
That's peace.
That makes plenty of sense.
That template, the default. I already see what I need to do.
Yeah, the depot template is inside of the Telegram. 'Cause I couldn't. Yeah, I had just downloaded it. So you guys ready for the SKV Act?
Yep.
This is only 4 pages. You ready?
Yep.
Yeah.
And a rep.
All right. 1666, chapter 11, 18, and 19. An act for redress of inconveniences by want of proof of the deceases of persons beyond the sea and absenting themselves, upon whose lives estates do depend. Recital. What happened? You can hear me?
Yeah. Yeah. Keep going.
Okay. I got the kids in the tub, so forgive my background. Recital that Sesti KVs have gone beyond the sea and that reversioners cannot find out whether they are alive or dead. Whereas, there go that whereas diverse lords of manors and others have granted estates by lease for one or more life or lives, or else for years determinable upon one or more life or lives, and it hath often happened that such person or persons for whose life or lives such estates have been granted have gone beyond the seas or so absented themselves for many years that the leasers and reversioners cannot find out whether such person or persons be alive or dead, by reason whereof such leasers or reversioners have been held out of possession of their tenements for many years after all the lives upon which such estates depend are dead in regard that the leasers and reversioners, when they have brought action for the recovery of their tenements, have been put upon it to prove the death of their tenants, when it is also impossible for them to discover the same, for remedy of which mischief so frequently happening to such leasers or reversioners. They can't get that. They can't get that paper. Here we go. Here we go. We have Sessi KV remaining beyond the sea for 7 years together and no proof of their lives. Judge in action to direct a verdict as though Sessi KV were dead. If such person or persons for whose life or lives such estates have been or shall be granted, as aforesaid, shall remain beyond the seas or elsewhere, absent themselves in the realm by the space of 7 years together, and no sufficient and evidence proof be made of the lives of such persons or person, respectively, in any action commenced for recovery of such tenements by the leasers or reversioners, in every such case, the person or persons upon whose life or lives such estate depended shall be accounted as naturally dead. And in every action brought for the recovery of the said tenements by the leasers or the reversioners, their heirs or assignees, the judges before whom such action shall be brought shall direct the jury to give their verdict as if the person so remaining beyond the sea or otherwise absenting himself were dead. Now we go, if the supposed dead man proves to be alive, then the title is revested. Action for mean profits with interest. So provides always that if any person or persons shall be evicted out of any lands or tenements by virtue of this action, and afterwards, if such person or persons upon whose life or lives such estate or estates depend shall return again from beyond the sea, or shall on proof in any action to be brought for recovery of the same, to be made appear to be living, or to have been living at the time of the eviction, that then and from thenceforth the tenant, the tenant or leasee who has outed of the who was outed of the same, his or their executors, administrators, or assignees shall or may re-enter, repossess, have hold, and enjoy the said lands and tenements in his or their former estate for and during the life or lives or so long term as the said person or persons upon whose life or lives and said estate or estates depend shall be living, and also shall upon action or actions to be brought by him or them against the leasers, reversioners, or tenants in possession or other persons respectively, which since the time of the said eviction received the profits of the said lands and tenements, recover for damages the full profits of the said lands or tenements, respectively, with lawful interest for and from the time that he or they were outed of the said lands and tenements and kept or held out of the same by the said leaseors, reversioners, tenements, or other persons who after the said eviction received the profits of the said lands or tenements, or any of them respectively, as well in the case when the said person or persons upon whose life or lives such estate or estates did depend are or shall be dead at the time of bringing of the said action or actions, as if the said person or persons were then living. That's it. Then we got, there are currently no non-outstanding effects of the SKV Act of 1666. This thing is in full effect, y'all.
Hmm.
Wow. Most of my studying today was a little bit on the trust, I mean on the will, but I was doing a little bit more research on the Declaration, um, actually where it gives us the right to do the things that we're doing.
So they said they be at 1666 is still is still active.
Mm-hmm.
So they do got people at C dead.
Yeah, everybody. That's how they get to do what they do. Report you as dead, they get to use your estate. When we have to show them that we're alive, take it back and administrate it for ourselves.
Well, this little 4 pages right here with the Cessna KV Act pretty much tells you exactly who they're talking about, what they're talking about. This is all about the estates, and the estates come from the names because the only way to find the lost people is through the names. So the profits and the interest that was created during the time that we've been lost at sea has to return back to us. But we have to take action first. And that pretty much sums this one up right here. This is a little 4 pages. But it says everything that's necessary for you to understand how we got this way, in my opinion. Anybody else on this Cessna KV Act? Hello, anybody there?
Yeah, I'm here.
Oh, anybody else have an opinion? Anybody else have an opinion on the Cessna KV Act?
What about Mateo?
Not here.
Huh?
Nope, I
You
don't
did
have
good,
anything.
John. You did good, man.
With what? What you talking about?
You're reading and breaking it
Oh,
down.
oh man, I'm trying to get to the meat and potatoes. Y'all talking about how I'm reading. I want to hear some other
We are
opinions
getting to the meat and
from.
potatoes.
So basically, from what I read, I'm trying to get a quick summary from everybody.
Mhm.
Like I said, I got what I got from it, but you might see something different. You might see something else. And the more we go over these documents and you express what you just heard me read, or I express what I just read, or whatever the case may be, we can bounce the ideas of what we're thinking, because you might say something that I didn't pick up from these little 4 pages. You know what I mean? That's
Only
why I
thing I
said,
see, John, is as long as they have us listed as dead and lost at sea, they can continue to keep using the mistakes. If we don't come forward to show that proof of life, to let them know we are living, they're going to just continue to use it. They're getting over.
yeah, I think this is where a lot of those people got those live life, those paramount life claims, those live life claims and stuff like that. This
Mhm.
is where this is where that comes from, but that's only one aspect of it. It's a very important aspect, but that's only one aspect of it. Because the Wills Act is a whole nother part of
I'm with John on that. What y'all? I want to hear some feedback on how y'all see that.
Well, I just said what I see.
it. Come on, y'all. Participation now. Come on now. Don't be shy. We trying to get free, ain't we? Don't let me be the only excited one here. I get excited every time I read this thing right here.
That shit power you up, don't it, John?
What? I'm juiced up here right now. You.
I've used a lot of the language in my wills and my trust.
Oh, you do?
Oh, absolutely.
Beautiful. Beautiful.
That's Miss Michelle.
No, that's Miss Rhonda.
Miss Rhonda.
Yeah.
Okay. How many of y'all on the line?
Myself, Rhonda,
4.
John, and Ross. Sensei must have had to drop off because he was on.
Sensei know a lot of this stuff.
Mm-hmm.
He know the beginning.
Okay, well. Let's go to this joint resolution, since we got everything we needed out of this says the KV Act. Go ahead.
How did you compare that to the deed poll? Y'all, I
Ooh.
ran to the store, so if y'all had something going on, I missed it all.
Now, y'all still see my screen?
Yeah.
Yep. Mm-hmm.
Yeah.
All right, so now let's go right back to this deed poll. Let's zoom in on this thing right here and just think
Now,
about what I
the depot is your executor letter.
mhm, to make the claim that you're not dead.
So on the executor letter is the titles that changes. The titles of the affidavit.
Mm-hmm.
Okay, so the depot is the number one template, and it changes by its presentment.
Mm-hmm.
Now
The
let's
old name.
depot fit the syndicated trust.
Mm. Yeah, I did hear you mention that too. You said something. Once you read that sets KV trust, you'll understand that deed poll better.
But that's what you make a claim to. She just said you got to make claim that you're not dead.
Yeah. For my old name will assume and adopt, determine, and take the use from the date of this deed of my new name in substitution for my old name. At all times from this date, all records, documents, and other writings, and all actions and proceeds, are as well as in all the dealings and transactions on all occasions, use my new name and substitute my old name. Mm-mm-mm.
You're not gonna substitute your old name.
Right.
Keep place. You just gonna
Mm.
show your new name is over all that.
Mm-hmm.
Over all that.
Yep. So wait, with the new name, the new name is not, so mine's is John Kelly Leroy, right? And when it says the old name and new name, would it be just the John Kelly?
No, your old name is what's on the birth certificate, and you're gonna add estate to it.
Mm.
Okay, there we go. Now we cooking with grease. Okay, and that'll be the new name.
And then your new name will be whatever you want to be called.
That's what I was asking you. Like, so the old name would be John Kelly Leroy State,
And
right?
you can still use your new name as the same name, but upper and lower, and it doesn't have the state on it.
Mm.
Oh, okay. Oh, okay.
The estate is what separates
Mm-hmm.
from
Oh, adding the estate because that's what they took off on the birth certificate.
yeah, they never put the estate on it.
Mm-hmm. Okay. So I was under the impression that, the new name would just be your first and middle.
Well, that's what I did because my name is Mateo F. Ramos. If y'all read the David Clarence thing, he basically lays out, even if you're reading that Cracket of the Code, they basically tells you that the difference, the separation of putting the estate on there and doing your upper and lower case as your new name is a separation.
Mm.
But because back in those days, they was giving it to a body and not to the computer. The
Right.
body can reject you because of the emotions of how they want to act. See what I'm saying?
Yep.
So it taught me that you just use your middle and your first and middle name for your new name.
Yeah. I picked that up when you showed when you did when you when you requested the EIN from the IRS.
Okay,
And I
so the
noticed you
old name would
specifically,
be Brian Keith Green Estate, and then the new name would be
Brian
upper
Keith Green.
lowercase.
Yep.
but he's basically saying whatever you want it to be at the end of the day. So he used his first and middle, right? But you don't necessarily have to do that. You can create whatever you want, but I get it though. I
Yeah.
see where you went.
I'll give y'all an example. You watch basketball, his name Ron Artest.
Uh-huh.
And he changed
When he
to World Medal
took
Peace.
on his new name to be the executor of Ron Artest, he brought his new name out as Man of World Peace.
Right. Right. Okay. Now, originally I thought you did that because of the IRS. Like you wouldn't want to put Mateo Ferdinand Ramos estate, then you put Mateo Ferdinand Ramos as the executive. So you
Well,
put Mateo Ferdinand.
it would still show separation because the estate is what brings the
Yeah.
separation.
Okay. Okay.
Another thing is on my birth certificate, it says Mateo F. Ramos. Yep. Ferdinand is not spelled out. It's just the middle initial, F.
Oh. Okay.
So
Okay.
I spelled it out. So now it's a big separation.
Oh. Okay.
But now
That's that
Ferdinand, I'm Providence.
exactly.
So my real name is just Mateo.
Right.
In the Bible, nobody had a last name.
Nope, they sure didn't.
They only went by their first name. So my name is just Mateo. Ferdinand is where Mateo reside. And Ferdinand was bequeathed to me from the estate, which is a state is God.
Mm-hmm. I'm gonna be from the Kelly Providence. I get it now, but see, that's why you said you got to put it up there like it's on the birth certificate. But the whole time, I never knew that Ferdinand wasn't spelled out on your birth certificate. See, Kelly's spelled out on mine.
It's okay. As long as you got state on your name that's on the birth certificate. You add a state on there. And you add it upper and lowercase.
Now, here's the funny part. My certificate of live birth from 1978 is upper and lowercase.
Yeah, don't worry about all that, man.
Okay, cool.
They did a switcheroo just so people wouldn't understand it. They had to separate themselves, so that's why they had to make everything all caps. They knew they had to go. They knew the power of the upper and lower, and they couldn't take the upper and lower position, so they put it in all caps.
Yep, because I got another birth certificate from the county that I was born in. Every time they give me one of those, it's all upper. But the original certificate of live birth from the capital, from Trenton, is upper and lower.
Okay. Now, the only thing that y'all missing right now from reading, because all this stuff you got to overlap, but you got to you got to get familiar with the language, is the IRM. Just like it starts breaking down generation, the skip generation is and all that. Y'all just read all that. Everything y'all just read is in the IRS code.
Yeah, it is.
Everything y'all just read. Everything y'all just read is in the IRS code.
That's crazy. Skip generations. Oh,
they
got forms and everything for that.
Will add to the damn. I can't say that one.
Set the KV.
Yeah, that all of that language right there and the way it's expressed, that's how the IRS starts on.
I think I remember seeing some skip generation on when you go to try to get an EIN.
It's definitely up there. Yep. I found that when I was doing the nonprofit.
Yep, all that y'all just said is there, but they express it in a different language.
Yeah, I listen to a lot of that language in everything that I do.
Now, who came over here and set up this Western way? Christopher Columbia, right?
Yeah.
Is it really Christopher Columbia? It's really his last name, Columbia. What the heck is the United States? What is their district?
District of Columbia.
Columbia, yep.
Yeah, Columbia.
So right now, somebody pull up. Well, you do it if you got the computer on your screen. Pull up District of Columbia. Pull up Washington, D.C., District of Columbia. Pull up the code and watch the symbol of that motherfucker. And watch what they call themselves. They don't call themselves a state. Like everybody else say state of. Watch what they call themselves.
Yeah, because they don't even have no counties.
No, the District of Columbia is going to blow y'all mind. The whole time we've been thinking it's a state, just like the other state. Watch what they call themselves. They don't call themselves a state. All right, I think I got to help them out. Let me get them to the right one.
Okay.
You got it in my damn folder.
You hear me? Y'all can hear me?
Yeah, we can hear you now, but you wasn't saying
Yeah, we
nothing
can
at
hear you.
first.
Oh, I was on mute. You
We
said
can hear you, John.
he said pull up the code.
Yeah, pull up District
No,
of Code. Washington, D.C. Say Washington, D.C. District of Columbia code. And they're going to pull up their laws and put in the syndicated trust. It's going to pull up that. I got it. It's title 42 something. All you got to do is put the syndicated trust, District of Columbia law. That shit going to pull right on up. It's in their law, title 44. I'm trying to find it, make sure I give you the right one.
Okay.
Hold on, I sent it to my mentor, so give me 1 second.
Title 42.
Yeah, there you go.
Okay.
Finding it, right?
Yeah, I'm reading. It's right here.
Legal
All right, so
estate.
don't it say syndicated act?
Yeah, it says
Oh my God.
There you go.
42.
Now, hold on. Now, look at the symbol of District
Legal
of Columbia.
estate. Holy.
Oh,
Look, y'all see that?
uh-huh.
There you go, right there. It's showing you how
Oh.
to make claim to your property. Now, but read the symbol for District of Columbia. What did that shit say?
District of Columbia, 1971.
What the top of that thing say?
District of Columbia.
Yeah.
It says council, don't it?
Oh, wow. You talking about up here?
Oh,
Yeah.
you talking about okay. I was looking at the little logo. Yep, the council.
You got me looking at the symbol.
They're the board of all the states.
Wow.
Holy smack and rolling.
They're acting like the damn UN. They're nothing but a switchboard.
Legal estate, incesticate use, exception, where lands, tenements, and
Herediments.
herediments are conveyed or devised to one person, whether for years or for a freehold estate, to use or in trust for another, no estate or interest, legal or equitable, shall vest in the trustee, but the person entitled, according to the true intent and meaning of such instrument, to the actual possession of the property and the receipt of the rents and profits thereof, in law or in equity, shall be deemed to have a legal estate therein of the same quality and duration and subject to the same conditions as his beneficial interest, except where the title of such trustee is not merely nominal, but is connected with some power of actual disposition or management of the property conveyed. Holy smack and rolly.
Now guess what? That same thing is in y'all property code of y'all state, but it might not say sticky. Here in Georgia, it say free simple estate.
Yep, fee simple. Yeah, yeah.
Free simple estate.
Mm-hmm.
When you
That's what
read
New
it,
Jersey says.
it has all rights. It cannot be involvable once you have declared it.
Oh my God. These people, boy. Well, not even these people.
Hey, John, you meant to say God did this.
Right. That's what I was about to clarify to
The District
myself.
of Columbia is nothing but a mutual lateral agreement.
Multi, yeah.
Same thing, and the UN is a bilateral shit. And the congressmen ain't nothing but members of all the states. They got a seat, they got a house, they got a room there.
Mm-hmm. Yep.
They got a registry there. That's all that is. They are registered.
And we need to take our seat
There you go.
and register our seals and move forward with our lives.
Mm-hmm.
Otherwise, the tenements, herediments are conveyed or devised to one person, right? It says it right here.
Who is the revenue?
Who's the revenuer?
Your estate is the revenue.
Mm-hmm.
Who
Okay.
is the tenant? You. See, all this is me, myself, and I.
Mm-hmm.
So you're the tenant of your estate. But since you didn't issue that stuff to yourself, you feel like you are a tenant to their estate. When the whole time you went in agreement.
Yep.
That agreement has left you as the revenue and they're the tenant. You change that verbiage around, you're the revenue and they're the trustee.
Mm-hmm. And the trustee pays all the bills.
Now they are accountable to make sure that the estate has clear view of all the stuff that it is doing.
Right, because there's no money anyway.
Right. So as the revenuer, listen to it. Revenuer, revelations, revenue.
Mm-hmm. Wow. Yes, and Trust, Chapter 15.
So that's not a state, that's nothing but a union. And all the states is part of that union on the domestic side. And that's how they hiding this shit. And that union right there is affiliated with the UN.
Mm-hmm. Do
Okay, so the UN is nothing but affiliated with Congress members.
here comes those bilateral and unilateral agreements.
There you go. They come in the form of the state code.
Mm-hmm.
So now,
Jointly seized.
now do y'all understand why why the Will Act and the Syndicated Trust Act and this right here, why it's so important that you gotta learn the language. And you gotta know who you are.
Absolutely.
Yes, they're doing the presentment, so you think they possess the power. You gotta put yourself as the one, as the revenue. You gotta put yourself as the tenant. So the OR is always gonna be the estate, and the EE is always gonna be you. And when you can sign your stuff over into an agreement, they become the trustee, and then anything that's part of your group become the beneficiaries.
Mm-hmm. Basically, you got to be the issuer.
There you go.
Mm-hmm.
But you're not truly the issuer. Your estate is represented.
Say again. The estate is what?
It's God.
There we go. There we go.
Okay? Because that's who appointed you. God did. Your estate is the promise of the Lord.
Wow.
You're going to hold on to that promise dear to your heart.
That's why you said this needs to be embodied.
Right. There you go.
There's no way you're gonna, there's no way you're gonna get absolution unless you fully determine that this is what you want to do and this is what you want to handle.
And you gotta make sure that now you can be granted this through man, or you can be granted this through the Most High.
I'd rather be granted by the Most High.
Absolutely. Because with man, there's flaws.
Right.
There you go.
Exactly.
But the Creator withhold nothing if you ask. All you gotta do is inquire and request.
And believe.
You go.
Wow.
That
Y'all
was the
see
very
this?
reason for me.
Y'all see my screen?
Yeah, I can see it.
Yeah.
With 1502, so it goes from 1501, the legal estate, then it gets even deeper with 1502, where several are jointly seized of lands to use of any so seized latter deemed to have possession and seizing alone.
Now, slow down. Go back to the Declaration of Independence and read the preamble.
Okay, let's go right there.
I can tell you off top. We the people
That's
of the
me.
United.
Ra.
What's that?
That's it. That's as he pulls it up. Let's hear it.
Okay.
My thing won't. I can't move this thing right.
Oh, where'd you go? I thought he was getting ready to read.
I was about to spit it off the top of my head.
That's what I said. Let it rip. I like to hear that, bro.
Come on.
Come on.
Come on, Rob.
We the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense,
Right.
promote the general welfare, and then secure the blessings of liberty to ourselves and our prosperity, do ordain and establish this Constitution of the United States of America.
No, that's not the preamble.
That's not the
Read that
preamble.
preamble, correct, John.
To the Declaration of Independence?
Yes.
Oh,
Right there.
that was different.
When in the course of human events,
There
it
you go.
becomes
Come on.
it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them. A decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. We
Oh, man. What the wheel gonna do? God said you get your equal, but
separate. Yep. Yep.
Y'all see that shit? And they
Yeah.
brought separation between human and people.
Mm-hmm.
Sure did.
Wow.
Sure did.
So you
Especially the word human.
You gotta declare to the world that you understand the difference between a human and the people.
Yep. Wow.
Now,
Fatal.
now you can read the preamble of the Constitution.
Let me get to the Constitution.
Now you gotta understand that Declaration of Independence is nothing but a truth affidavit from the United States.
Mm-hmm.
Yeah, that's what I was studying mostly today.
I don't know if I got the preamble on it.
I don't think so. It's just Congress shall make no laws respecting the establishment of religion.
Oh, yeah. Congress can't do what?
Shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech.
So what they just say, they can't stop Jesus.
It definitely can.
Stop Jesus. Now, what gives you now read Article 4 real quick of the Constitution. Y'all gotta remember the Declaration now. Y'all gotta remember it's saying that y'all gotta write the laws that gives you the right to declare this cause.
The right of the people.
The Declaration is one of the laws. What's the other one there, brother?
The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated.
Hold on. Let's go to number 2 first.
Article 2.
Article 2, what that say? Because you already read Article 1, right?
Yeah.
Yeah, that was Article 1. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed.
What did they just say about your right?
The right of the people shall not be infringed. Yep.
Right. They're not talking about no damn guns.
Guns were.
They're not talking about no guns.
Your seals.
For revenues. Is an account revenue manager.
Say that again. Say that again.
Forms, right?
Uh-huh.
That's account revenue manager system or service. So hell yeah, you're going to connect arms. You're going to connect shoulders with your brothers. You're
Right.
not talking about no damn gun.
Right.
All right,
Wow.
what free say?
No soldier shall in the time of peace be quartered in any house without the consent of the owner, nor in the time of war, but in a manner to be prescribed by law.
So you think a soldier of the Most High, it's got to be, you think they got the right to capture it?
Absolutely
Hell
not.
no.
Mm-mm.
So it's a protocol when someone proclaimed to be a child of the Most High. They got to identify that child and let it go. Now we can go to number 4.
The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause supported by an oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized.
Okay, now that's a whole lot right there. We just gonna slow down for a minute. Now, y'all read the Will Act and y'all read that 166.
Yeah.
What was they telling y'all all in there? They was telling y'all about every damn thing that comes from y'all. Y'all got a right to securitize that shit, right?
Mm-hmm.
Yeah.
That's what Article 4 is. It said person, person is a human.
Right.
Fictitious entity. Person is a trust, an estate, a corporation, a nonprofit. Trust is a person is all of these specimens. It says you got a right to secure your person. You see that?
Mm-hmm.
Yep.
All right, what number? All right, now hold on. And it says securities, your paperwork, and all that stuff, right?
Yeah, house, papers, and effects. Yep.
That's what we're doing.
Letters and partials, ain't it? Everything is in a letter or a partial. It come through the mail to you, don't it?
Mm-hmm.
And they specifically put papers on there too.
Okay.
Oh man.
Now what number 5 say?
No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment of or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia. When in actual service, go ahead.
But no, you finished. Go ahead and finish your reading.
Okay, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation.
So that means no person can be put in court, huh?
Yep.
And no person can be a witness of their damn self, huh?
Mm-hmm.
Do y'all hear what they saying?
Yeah.
A person can be fictitious entity. A corporation can't go to court.
Right.
Mm-hmm.
A live body.
Everybody in jail right now deserve to be in jail because all that is they identifying themselves as a person.
Yep.
Instead of the people. We the people. Okay? Another thing is, it says if it says a person can't be held in court, why? Because a building can't goddamn go to court, can it?
No, it can't.
That's a fact.
How's the bank in the building going to court?
So they bring the employees of the building.
Mm.
Are you the employees of the damn building?
Hell no, but we've been acting like it.
Y'all the beneficiaries of the building. Who the employees? They ask. They're trustees. So, you know this stuff. They won't take your ass to court because they know they taking themselves to court. All right, what number 5? Oh, that was 5?
That was 5. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witness against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense.
Y'all hear this? A speedy trial. Y'all, speedy means hear up and verify the entity. So if they're not supposed to load it, they shut it down. If they identify, leave it alone, they shut it down. If they identify that they can move forward, they move forward following the procedure. So it's all about identification. If you know who you are, it's a process of identifying you, and they have to do it real speedy. They know how to present yourself. Because you cannot be held captive over 72 hours.
Right.
They have a grace period of 72 hours to identify you.
Yes, it is.
And it was shut down the case once they identify you. If you don't know who you are, it will allow them to proceed. All right, now we're going to read the last one. 7.
In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law.
So, y'all, if you study in common law and you present it, that means a jury cannot goddamn go against it. So, will you ever be in that court? Hell no.
Oh.
Because it's a fact already. The law is a fact. How the hell they going to bring you in court if you in compliance? As long as you're in compliance, they can't bring you to court. There's nothing to rebut.
Right, because you can't rebut a fact.
Yeah, you can't rebut a fact. So there's no need to be in court. You gotta read no more. Everything else is amendments.
Oh, okay. Oh, yeah, it was the first 7.
With 7 articles.
Right.
Everything else is amendments. We ain't trying to sue nobody.
Right.
We ain't got to do all that. Justice is going to speak for itself. The vengeance is the Lord.
So I guess that's where, once this is embodied and put in place, that's how you become an auditor. Because the minute they try you, they're trying themselves.
You a whistleblower over there, buddy.
Huh? What happened?
Put your damn whistle around your neck.
Oh, man. Now, I just heard you say that you've become an auditor without auditing. And if I'm understanding this right, this is where it's coming from.
There you go. Because you know what's going on.
And they can't rebut a fact. So come on in. Come on with it. That's what.
When you understand the separation, you can present it.
And the separation is a fact already. It's been a fact all our lives.
And they know your estate is your shield. God is your shield. So they ain't fucking with God.
Shit, they recognize him with that resolution. They recognize him with that resolution they put out.
There you go. They ain't fucking with God. Now you can go read that resolution. There you go. I'm always trying to show y'all the order, how to see this stuff, and the power of the reason why y'all gotta know this stuff. Because if you don't know it, how you gonna make your claim?
Let's see here. Where's that resolution? I'm going.
Now everything that we read is already been described. All they doing is just bringing it life.
There go that whereas. authorizing and requesting the president to proclaim the 1983 as the year of the Bible. Whereas the Bible, the Word of God, has made a unique contribution in shaping the United States as a distinctive and blessed nation of people. They go to word people again, not persons. Whereas deeply held religious convictions springing from the Holy Scripture led to the early settlement of our nation. Whereas biblical teachings inspired concepts of civil government that are contained in our Declaration of Independence and the Constitution of the United States, whereas many of our great national leaders, among them President Washington, Jackson, Lincoln, and Wilson, paid tribute to the surpassing influence of the Bible in our country's development. As in the words of President Jackson, that the Bible is the rock on which our republic rests. Whereas, the history of our nation clearly illustrates the value of voluntarily applying the teachings of the scripture in the lives of individuals, families, and societies. Whereas this nation now faces great challenges that will test this nation as it has never been tested before. And whereas that renewing our knowledge of and faith in God through Holy Scripture can strengthen us as a nation and a people. Now, therefore, be it resolved by the Senate and House Joint Resolution of the United States of America in Congress assembled that the President is authorized to request to designate 1983 as a national year of the Bible. In recognition of both the formative influence the Bible has been for our nation and our national need to study and apply the teachings of the Holy Scripture. Year of the Bible.
Now, y'all.
What you say, Mateo?
Now, what was that? Somebody was speaking?
That was something in the background.
My bad. That's me.
Now, do y'all see? That's your wheel. That's your wheel right there.
Sure is.
Look at your wheel right there.
Apply the scripture.
That's right there is the reason why you want to write your wheel. It's telling you that God is your construction, your tools, your foundation, what constructed your damn wheel. It's telling you right there what constructed, what brought the construction and the foundation to the United States. Jesus.
Jesus. Yeah, it's definitely contained in their Declaration of Independence.
Yep, and the Constitution.
And the Constitution. That's why it's imperative to implement the same. So, again, ultimately,
That's your of your will and your daggone truth affidavit right there.
Mm-hmm.
That would be your trust certificate.
That deed poll.
The thing missing from that, you have to have the mirror version of the state laws. So all that whereas where it's talking about the Bible and that, you would have to say your state laws.
Mm-hmm.
The statutes at large law. So because the way I want y'all to really see this first is altering. Don't worry about abolishing. That's going to come. Y'all will see that once you understand altering. So once y'all understand all the domestic code, and y'all know that the statutes at large, public laws, are the highest laws over here on American land. They derive from the treaties. So once you understand how to utilize the public law, they're over the United States Code, they're over the states code. They're already facts. States codes and the United States codes are multilateral agreements of it.
Mm-hmm.
So that supersedes their stuff. Because that's the people's law. They had to get the agreement from the people first. So you think the people gave up their immunity? Hell no.
Absolutely not.
So that's why they call it public law. It's the people's law.
Mm-hmm.
Once y'all get the foundation of who y'all are and create your will and create your truth affidavit, that's the rock you stand on. Didn't they say that?
Yes, sir.
That'll be your rock. That'll be your rock. That'll be your foundation. It's founded with the Lord. So y'all know we got to start having scripture on this line, right? We got
That's right.
And so now what we just did, we did the year of the Lord. What's next up there, brother?
Let's go back here real quick. So we got after we did the act, the deed poll, Declaration of Independence was after that. The Articles of Confederation is next.
All right. So after the Article of Federation is the Constitution, which
Yep.
the Articles of Federation it's still in place. It was never abolished.
Mm-hmm.
That's why they call it. If you read the laws, they say the Confederates.
Yep.
Federation.
Yeah,
Or the
that's true.
Federation. They took the con off and just say Federation.
Mm-hmm.
Okay, so CFR is they ass.
Wow. Code of Federal Regulations.
Right. That's the Constitution. I mean, that's the damn Articles of Confederation.
Mm-hmm.
All right. In the Articles of Confederation, Article 10 is what gave the authority to the United States to create the Union.
Yep. Let's go down. Let's go down. It's 8 and 10 is right here. What is 10? And this one is long. What the hell is 10?
I watched the movie Jamestown. It would show y'all what I'm talking about with the Article of Confederation and the Constitution. Movie Jamestown out to you.
What's it called again?
Jamestown is where the white man went and joined the Union.
Matthew McConaughey or something like that?
Yeah.
That's the actor
Yeah.
name? Okay.
When he came back, he got with the black people and moved out to the Bronx and got the black people to vote for the Union because the Confederates was acting their ass. And he helped form the Union. And he used the black people for it. But he was cool with the black people.
Yeah, he was.
You gotta take this shit.
Is it called the state of? It's called the state of Jamestown, right? Something like that.
It might be, brother.
Yeah.
But that's what. All right. So now we done read. Now y'all know about Articles of Confederation.
Mm-hmm.
All right. What's the next document after that?
That's the Constitution. We read that one. Then you have the 17.
Showing us again. That's the Emancipation Proclamation, right?
Nah, the
Land ordinance.
An ordinance.
Oh, okay.
Yeah,
All
Western Territory.
All right. So now, y'all, I think I did this a little backwards. I should have put the land ordinance and the Northwest ordinance before the Constitution because that's the history of the Constitution. This is the meaning of the Constitution. So when you read the land ordinance and the Northwest ordinance, I think if you skip the land ordinance and go to the diaphragm of the land ordinance and the Northwest ordinance, this is diaphragm.
Mm-hmm. Yeah, it's the diaphragm is last.
Mr. Norris, can you bring the phone a little bit to the screen? Like it's tilted.
Oh, okay.
You had it in a good position. It was just tilted back.
Okay.
Yeah. And there you go. Now you can go back to the photograph. Not that one. The diagram. There you go. So now y'all remember when the Declaration says separate but equal stations.
Mm-hmm.
So the Northwest Territory and the land ordinance shows you equal and separate stations. And I think that's neat, right? They showing us this stuff. So this is how they started getting their equal but share station. All right. Now, one thing that I forgot to put in here is the George Washington document where he petitioned to the Morocco Empress at the time to be able to do all this.
Yep.
Oh,
I
wow.
read that. I read that one. Yep. He sent that letter. He sent that letter or that parcel off.
Yeah, he sent it to the Empress of the land at the time.
Yep.
And asked, can he get the authority to do this? And in that letter, y'all, he says that he's sorry that they did not pay the debt that they promised. He said
Yep.
now he comes with new energy to pay off that debt. And that new energy is the people that he has securitized.
Mm-hmm.
So that's okay. So I heard where they said Morocco was really over here in America and not over in Africa like they claim it to be.
Yeah,
Morocco and Africa ain't come out till 1956.
the emperors are over here.
Okay.
Mm-hmm.
This is Africa.
Mm-hmm.
Africa, all of the lands used to be one, y'all.
Pangea.
And then over the years, it broke up from the weather and stuff and created different continents. So this is one piece of land and everybody want to make it separate. But they're showing you how they acquired their rights to the land. I don't know what I was thinking. I need to go upload that letter for y'all. So y'all can read George Washington letter. Since he was the first president.
Hey, Janoris, ask Mateo why they don't teach that in school.
Well, we in school now.
That's right.
We in school now.
Land sold for $1 per acre.
You in class too, because you can hear
it. He all the way in the room.
And got his ear all the way in there with you.
Yeah.
That's right. You can't deny that energy. Can't deny that.
God traveling, ain't it, bro?
Mm-hmm. Huh.
I'll let y'all go over that yourselves, but it just shows how they got their equal and separate stations.
Mm-hmm.
All right. So now they're doing nothing but acting as hubs and routers to make sure this information get from one place to another. All right. Now remember, they got to keep showing the people this stuff. So now they're showing you that the upper and lowercase United States was 1776. 1789, that's when the all caps United States came out. Okay? So now you got a right to break away from their ass. So now this is how they're telling you got the right to break away from their ass.
What, this proclamation?
Yeah.
Can you see the screen okay, Mateo? I'm trying to prop the phone so you get a better view.
I can see it.
Okay.
But I know this stuff by heart, dude.
Whereas.
Yeah. Go ahead, John. Read it for me.
Okay. On the 22nd day of September, in the year of our Lord 1862, a proclamation was issued by the President of the United States, containing, among other things, the following to wit: that on the first day of January, in the year of our Lord 1863, all persons held as slaves within any state or designated part of a state, that the people whereof shall then be in rebellion against the United States, shall be then thenceforth and forever free, and the executive government of the United States, including the military and naval authority thereof, will recognize and maintain the freedom of such persons, and will do no act or acts to repress such persons or any of them in any effort they may make for their actual freedom. That the the executive that the executive will, on the first day of January aforesaid, by proclamation, designate the states and parts of states, if any, in which the people thereof respectively shall then be in rebellion against the United States, and the fact that any state or people thereof shall on that day be in good faith represented in Congress of the United States by members chosen thereto at elections wherein a majority of the qualified voters of such states shall have participated, shall, in the absence of strong countervailing testimony, be deemed conclusive evidence that such state and the people thereof are not then in rebellion against the United States. Now, therefore, I, Abraham Lincoln, President of the United States, by virtue of the power in me vested as Commander in Chief of the Army and Navy of the United States in time of actual armed rebellion against the authority and government of the United States, and as a fit and necessary war measure for suppressing said rebellion, due on this first day of January in the year of our Lord 1873, and in accordance with my purpose so to do, publicly proclaim for all full period of 100 days from the day first above mentioned, order and designate as the states and parts of states wherein the people thereof respectively are this day in rebellion against the United States, the following to wit: Arkansas, Texas, Louisiana, except the parishes of St. Bernard, Plaquemines, Jefferson, St. John, St. Charles, St. James, Ascension, Assumption, Terrebonne, Laforge, St. Marie, St. Martin, Orleans, including city of New Orleans, Mississippi, Alabama, Florida, Georgia, South Carolina, North Carolina, and Virginia, except the 48 counties designated as West Virginia, and also the counties of Berkeley, Accomack, Northampton, Elizabeth City, York, Princess, and Norfolk, including the cities of Norfolk and Portsmouth. And with accepted parts are for the present left precisely as if this proclamation were not issued. And by virtue of the power, and for the purpose aforesaid, I do order and declare that all persons held as slaves within said designated states and parts of states are henceforth shall be free, and that the executive government of the United States, including the military and naval authority thereof, will recognize and maintain the freedom of said persons. And I hereby enjoin upon the people so declared to be free to abstain from all violence, unless in necessary self-defense. And I recommend to them that in all cases, when allowed, they labor faithfully for reasonable wages. And I further declare and make known that such persons of suitable condition will be received into the armed services of the United States to garnish forts, positions, stations, and other places, and to man vessels of all sorts in said service. And upon this act, sincerely believed to be an act of justice warranted by the Constitution upon military necessity, I invoke the considerate judgment of mankind and the gracious favor of Almighty God, in witness whereof I hereunto set my hand and cause the seal of the United States to be affixed. Done at the city of Washington this first day of January, the year of our Lord 1873, and of the independence of the United States of America, the 87th.
Now, I want to hear y'all, did y'all hear in that proclamation, did y'all identify with certain words and what they said?
Anybody? Come on, y'all. I don't want to be the only one with my hand up all the time.
I was in the shower when you was saying that whole thing, but the only thing that stood out to me is the United States, they had to put in their independence again at the end. Like, we know you're independent, but that was just funny. The last word that I picked up. But I was hearing you through the shower, but I didn't hear anything.
Let you know that no person can be enslaved no more.
Mm-hmm.
United States instruments are called persons.
Yep.
So anytime you rebel, they said that them and all the states have to acknowledge it, even if it's not in the circular. They got to acknowledge your present testimony. Your rebellion is what. So y'all, when y'all go in court, just call out Emancipation Proclamation gave me the right. It just told you. Just said it. You saying what they say in the year of the Lord, such said. You go in that motherfucker say in the year of the Lord, 2024, the Lord said, I got the right to proclaim my rebellion. And with that, y'all have to follow suit. That's what that document just said. So when you're utilizing your will and your truth affidavit and you're presenting it as a trust instrument, what they gonna do? Fall in line.
Yep.
All
Recognize.
the government gonna fall in line and protect you. Their military is gonna protect you. So if you look at all the governors say the same thing as the president, that they are the chief and commander of the military of their state.
Yes, sir.
So what y'all doing? Y'all declaring? What's another word of declaring?
Proclaim. Yep.
Proclamation is proclaiming.
Publicly proclaim.
There you go. What's the next document?
Let's see here.
If I give y'all this quick outline,
Yeah. Yeah, this was. I know. I forgot what you told me this was, but this is.
I think it's the bottom one.
It's the bottom.
Yeah.
Okay.
What they say? Not when I say that. Go back up. Just start off with the first page. Go to the first page in the middle of it. You see?
Okay.
Right there. Right there.
Act to prohibit
the Senate and the House. Remember, it's a joint. It's a joint thing. Senate and the House make a joint resolution. You see it say being acted by the Senate and the House? Start reading from there. Well, go down and then start reading because that's the stuff that you read. The stuff up top come from another.
Okay. Right here?
Yep.
Yeah.
Okay. That from and after this passage of this act, no claim for a pension or for an increase of pension shall be allowed in favor of the children or other descendants of any person who served in the War of the Revolution or of the widow of such person when such person or widow died without having established a claim to a pension. That one right there, claims for certain pensions or slavery in the District of Columbia abolished.
Now keep reading up under that.
Okay.
They're telling you right there, a widow of such person when such person is a widow without having it. All right, now keep reading.
Okay, an act for the release of certain persons held in service or labor in the District of Columbia.
What did it say? Read that again.
An act for the release of certain persons held to service or labor in the District of Columbia.
What they just say?
It said persons. It didn't say people.
And it said held to service or labor.
Right.
What the hell people doing right now? Acting as employees of the District of Columbia.
Yes, sir. Yes, sir. Be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled that all persons held to service or labor within the District of Columbia by descent are hereby discharged and freed of and from all claim to such service or labor, and from and after the passage of this act, neither slavery nor involuntary servitude, except for crime whereof the party shall be duly convicted shall hereafter exist in this said district. And it be further enacted that all persons loyal to the United States holding claims to service or labor against persons discharged therefrom by this act may within 90 days from the passage thereof, but not thereafter, present to the commissioners hereinafter mentioned their respective statements or petitions in writing, verified by oath or affirmation, setting forth the names, ages, and personal description of such persons, the manner in which said petitioners acquired such claim, and any fact touching the value thereof, and declaring his allegiance to the government of the United States, and that he has not borne arms against the United States during the present rebellion, nor in any way given aid or comfort thereto, provided that the oath of the party to the petition shall not be evidence of the fact therein stated.
You ain't gotta say, y'all don't feel that shit. I don't know what to say. Y'all don't feel that. I don't know what to say. All the rest of the stuff is some good reading too, but you don't have to read that. Let them. They need to understand this because you was up there choking, reading this shit. You were powering up. You wanted to stop. Y'all see that? It says
Hell yeah.
personal description. What that D-Pole say?
Yeah, yeah.
There it is.
Old name, new name, everything.
Oh my God. Y'all look at this goodness. God's good, y'all. God is good.
Yeah, it said setting forth the names.
All the time.
Indeed.
All right, y'all. Now, next two documents we don't have to go over. The next one is showing how a date back in
1493. Yeah.
stuff going on, and they call it Pepe the Bull. Y'all know it's a TV show out right now where a guy they call it the Bull.
Mm-hmm.
And that's what it's based off of, this document right here.
Oh,
Document of discovery.
okay.
Wow.
Yep.
Okay.
He said the Bull. He did the same thing of everything you just read. Happy the Bull did this.
Mm-hmm.
All right. Another thing about this is the bull, right? What Disney show came out for the children about a bull with a certain name?
Ferdinand.
The damn bull name was Ferdinand.
Oh,
Ferdinand.
oh.
Yes, it was.
Wow.
Y'all see the goodness of the Lord? And y'all, the Emerald tablets is the Bible and the law on a very short version. Like if you really, really understand what's going on and you read this Emerald tablet, it'll blow your mind.
Mm-hmm. Yeah, I read this one a couple years back. It's definitely a shorter version.
Right. So now we did the outline. Now y'all see why it's very important for y'all to do your will and your truth affidavit.
Mm-hmm.
All right. And then I'm gonna talk about how we're gonna draw up your postal letter because your estate is a post.
Okay.
And the post is what gives notice to everybody.
Mm-hmm.
So before you send your stuff off to get great seals and stuff, we're gonna go over the post.
Okay.
Okay. Excellent.
There's many grids that overlap this stuff, but we got to take it one step at a time. As the old school people taught me with the Bible, one scripture at a time.
So excited. Like my daughter be saying, so excited.
But now y'all can see it now, right?
Yeah.
Absolutely.
Yeah. That's good. I need for y'all to be able to see this. That's why I harp on the will and the truth affidavit. It's kind of hard to move forward if you don't embody this stuff right here. This stuff right here, and we mixed it with the Bible without even pulling out the Bible. You see that?
Mm-hmm.
The laws put the Bible all in it. And we did a joint combination there. We did the Bible and the laws together right there. We just did that, y'all. We did a joint collective view of how the Bible and the law present God. All right. Now, once y'all get these documents together, and before we send them off, we go over the post. I'm going to connect y'all to the post file so that y'all can start learning the post. All right, and the power of the post before y'all start sending your stuff off, because a lot of people want to walk in these places. Walking in, your ass gonna be limited. You gotta present it through the mail, and they can't deny it, or they can't tell you nothing crazy. You giving them the order, you giving them direction. They're not gonna give you advice. You're gonna give them the advice what to do with your mission.
Change the seat.
Because we got the power.
You got the power, dog. You got to change the seat. Take your office.
Well, because when we go over the polls, once y'all start understanding this, those who pick altering, we're gonna run with it the altering way. And those who pick abolish, I don't mind showing them the abolish way. They're the same thing. Remember, it's a joint combination. It's just I don't mind showing who want to go which way. I don't mind showing them, all right? But I know most people, when y'all see the altering way, you'll be able to see the other way. And when I connect y'all to the post, y'all will get the free stamp and all that stuff, if y'all ain't already got it.
Okay.
Yeah, I sent that free stamp out to all the groups. I altered it in Word and sent it out to everybody, and I used it too.
I've been using it. That's all I use now. I don't use regular postage.
Mm.
Then after we learn postage, because there's many layers of postage that I'm not going to do that to y'all. I'm just going to get y'all to understand the general post, because y'all are the general executives. So you need to understand how to act as a general post before you send anything out from your post, from your home. Your home is your post. Your estate is your post. So before anything leave your estate, you need to make sure you act as a post, a post office. So after that, then we'll go into the security acts folder, so that y'all can start understanding all this verbiage of securities.
Okay.
So that's where the meat and potatoes is. Right now we on the milk.
Okay. I
The milk.
dig that. Definitely dig that.
That's
So let me ask you a question, Mateo.
Go ahead, buddy.
Now, in the time frame that you were learning and you did your process, you went straight to the IRS to report the death, right? Or did you inform Social Security first?
They switched it around now.
Okay.
Making y'all go directly to the Social Security office. Back when I did it, we was able to do it directly with the IRS.
So basically, Social Security needs to know first, because once you inform them, well, they're gonna have to do the transfer, basically.
Right. They're gonna close the account. They're gonna make sure they settle the debt, and they're gonna send all the credit that you made off them. They're gonna send it back.
Now, since the EIN number for the estate already exists, they're gonna do that before you even get the EIN number, aren't they?
Yeah, they're gonna do all that. We're gonna come to that part, brother, where you're gonna learn about debits and credit.
Okay.
You gotta learn y'all seen when the Queen was dying, the Queen of England was dying. Y'all seen how they came on TV and called in all the creditors and debtors.
Yes, sir. Yes, sir.
So that's what y'all are doing, calling in all the creditors and debtors.
Mm-hmm.
But how y'all call it is by giving notice to those who created it.
Yep.
Okay? Because they created the account, they gotta close the account. All right, so they did switch it around since I've been. Now y'all gonna learn how to give notice once y'all get your stuff constructed up. And that's why I say you gotta learn about the post first, because y'all gonna learn how to give notice of your status change.
Mm-hmm. Okay.
Okay, y'all. So y'all gonna get to that point. Y'all gonna give the notice. The shit gonna leave y'all and go out to the world. Okay? But y'all gotta understand, man. Y'all gotta understand Emmanuel first before y'all can consign it over to someone.
Mm-hmm. Okay.
Or appoint someone or delegate your authority to someone. You gotta first know your stuff before you give it back to them.
Okay.
Because I gave my EIN number back to them so that they can make sure it's in the system.
Mm-hmm.
I surrendered it right back to the system so it made sure that I'm okay.
Is that sirs you're speaking of, sir?
Say that, yeah, I put it as, well, sir is the Lord's language for it. That's the state language.
Okay.
International language is the IRS.
Okay.
I mean, federal level is the IRS.
Correct.
International is the IMF.
Mm-hmm.
And universal is the UPU.
Mm-hmm.
Y'all gonna do the universal off the rip.
Yep.
Because I'm gonna make sure y'all have a postal state of mind. Because y'all constructing letters and parcels.
Mm-hmm.
To beat the post, y'all need to understand the power of the post.
Excellent. Excellent. This is a whole reprogramming process.
Yeah, it's just so many layers that you gotta consciously understand these layers before y'all just start acting.
Mm-hmm.
Y'all, I jumped off. I didn't know nothing about nothing. And I had to read. And Mr. Norris can tell y'all, I be reading in front of her. And I fly through this stuff because I done programmed myself just to read.
He tell me to close my eyes. Then he goes so fast through the documents.
It's like second nature now.
Say that again.
It's like second nature now for you.
Oh, yeah. It's me, and I'm it. It is me, and I am it. I am the I am. So it's not really me, it's the creator. I identify with the creator. The creator says, I am the word, and the word is me. So by y'all comprehending the word, y'all are identifying with the creator.
Hmm.
I
This is
didn't know
way,
that, y'all. I came to understand this stuff.
yeah, this is way bigger. This is way bigger than just, putting some paperwork out and, trying to get some debt relief and all that. This is a complete reprogramming process. And it has to be embodied. So understanding the documents a key initially, and I see where you're going with it, Mateo, because all these parts are connected. But if you're not understanding the different layers of this cake, then you ain't gonna be able to bake it.
Right. Well, if you bake it, it ain't gonna taste right.
Yeah, it ain't gonna taste. It ain't gonna be
That's
delectable.
good.
I need it to be delectable. So So I want my recipe. I need the grandma's recipe where she put the sprinkle of cinnamon. She ain't measure nothing. You know what I mean? So I get it. It has to be embodied completely, wholeheartedly too.
But what do the Bible say? God said, fuck the letter. It's gotta be subscribed to your heart.
Yeah. Hmm.
So all this stuff you're drawing up, God don't give a fuck about person. He doesn't respect person.
Yeah, that's what it say.
Hmm. Yeah.
So your letters are a person. And God don't give a fuck about it.
Hmm.
He only respect people. He only respect his children.
Right.
He cover his children.
That's why I must surrender.
Yeah, there you go.
Gotta surrender. Otherwise, your paper's just gonna be papers.
Well, it'll be worth it. Yeah, see right through it. They'll
Your
know
public statement of pause your brand and stream.
Slow down.
Hey, Trent, why don't you back some
see, there's nothing wrong with looking at people template. But a template can fool you by it can be misinterpreted. And I'll give you a good example. Rob brought up a template that I guess he got off the internet or something about this. And that template was on point. It was right. But the whole thing about it, if Rob is consciously understanding the laws of that 166, he will see where it will allow them to draw up that template like that. And then it will allow him to draw it up. But the deed poll is so simple that it really throws people off. So the true connection is to understand the OR and the EP. To understand the estate is the revenue, the revenue, and the upper and lower case is the tenant. Once you understand the separation, then you can move forward with this stuff. Because you're going to present yourself different. Everything that you go in contract with, you will put the all caps, the state on it, and you will sign with your upper and lower case.
Hmm.
You can't take a corporation.
Yeah, that was study material.
Y'all just
That was study material.
corporation to court.
He said,
There's a reason why they can't take a corporation to court.
if you do
Because
a
there's rules and
contract,
regulations already set for corporations.
you fill it out with your all
Okay,
caps
okay,
name
I
with
remember that.
the state after it, and then you sign in your upper
Upper
lower.
lower, okay.
Naomi, what y'all over there talking about?
Oh no, he was just asking me what Mateo was saying. But when you do a contract, you're gonna put your all caps with the estate, and then you're gonna sign with your upper lower.
Oh, okay. Yeah.
You never go in contract with your upper and lower. You never go in contract with your upper and lower. But then they can take your ass to court as a person.
Hmm.
Always go contract with the all caps and sign with the upper and lower because it takes a body to authorize stuff.
in person.
Mm-hmm.
To learn that in business.
A corporation can't do nothing. It takes a body to do it for the corporation.
Sign your upper.
Even with the corporation, there's a separation because somebody has to have the seat to administrate the corporation.
Right. But also remember everything y'all just read. They can't take a person to court. They can't take a corporation to court.
Mm-hmm.
Right, business 101.
Office to office. Pop no swindle. Sweeper no swipe.
Hmm.
Good stuff. Good stuff.
Okay. Now the meat and potatoes go into the security.
Mm-hmm.
And once you understand how these securities are presented, then you can bring discernment to them. Because the stuff that y'all drawing up are securities. And y'all gotta register your security. You gotta register it in the form of your trust. Now those who's gonna alter your trust instrument will have on top of it a declaration dispatch note. Because there's a custom declaration dispatch note. Because custom is take priority over all mail.
Mm. Mm.
You said that's only for the altered?
No, Abolish they're gonna do it too. But you're not gonna have it on your trust instrument. You'll have it on your ID.
Oh, okay. Yeah.
Yeah, they're gonna have it on their trust and on their status change.
I thought you said corporate badge.
Well, y'all don't need a corporate badge, those that's gonna alter, because you're gonna take the status change affidavit into all the corporations that got accounts of you, and they're gonna update the status in it. That's why you're doing a notice of status change. That's a notice of status update. And they're gonna go in and put your new status in it. So your driver license will have your diplomat immunity in it.
Mm.
Everything you do will have your immunity subscribed to it. Y'all got passports, you will go back and we're gonna send a notice to them. If you whatever instruments y'all got, we're gonna go and give them notice of it. Those who gonna abolish, the notice you're gonna give is a withdrawal notice.
Okay.
You're not gonna do a change of status.
Now we have 4 people in participation right now, right?
Right.
And
Have you guys determined whether you want to alter or abolish yet?
I'm abolishing.
Same here. I just want to just abolish and be done with it.
I definitely want to abolish.
Abolish.
We have a unanimous decision to be abolished.
y'all,
We're out of here.
once y'all get your 3 instruments together, then it's a lot more reading y'all gotta do because y'all want to abolish.
Mhm.
So we're gonna
Bring it on.
be able to abolish and stuff, but I want y'all to send your package off at one time. I don't
Okay.
want y'all to be like me and I done sent many packages off. I had to amend my ways.
Okay.
When y'all could just send one package off.
And that was a blessing in itself, though, because ultimately, if you didn't have to amend your ways, then we wouldn't be here today.
Oh yeah. I love the fact I had to amend my ways. I mean, y'all gonna still amend y'all ways. Y'all doing it now. It's just y'all not gonna be. I'm acting as the Secretary of State. You see what I'm saying?
Mhm.
So to be like y'all be doing y'all inquiries and requests with me before y'all do it with them.
Mm-hmm.
Perfect.
And tell you, let me find out you got that smart system over there, man.
All I do is my inner. It's my
That's right.
AI.
That's right. That's right.
John, I told him that was your nickname, but yours stands for the absolute intelligence.
I need to upload these damn legal papers now. So, oh Lord.
So, based on
Definitely.
what we just got today, y'all, so are we in agreement that we can move forward with these documents? Because we pretty much just like Ambassador 101 or Abolish 101. We went through the starting folder. Of course, we still got to reread. So this stuff is ingrained in the membranes.
We're
Heck
definitely
yeah.
in agreement.
Definitely
Yes.
in agreement.
As y'all sitting there constructing up your will and your truth, your Declaration of Independence, truth affidavit,
Mhm.
and we put together the trust instrument. Once y'all start doing all that, y'all by the time it's time to send this stuff off, y'all will be on it. And by I hope y'all surrender. Y'all have to surrender to the Most High. Y'all not surrendering to me. Y'all have to read this stuff and take it to the Most High.
Mhm.
Inquiry and request with the Most High. I'm just here to piggyback because I'm gonna send you right back to the Most High.
As you did.
Yeah, I'm gonna lead you to God.
Indeed.
That's this stuff, y'all. The Lord brought my understanding to me.
Okay.
I think my
Fucking all these bilateral and multilateral.
say that again.
know how they call them rabbit holes? These rabbit holes are these bilateral and multilateral agreements.
True indeed. Just like that streamlined sales tax agreement.
Right. That's a multilateral agreement. Y'all, we're gonna get to that. We're gonna get to the streamline. I got a whole folder just for the streamline. But y'all gotta understand what a security is first. Y'all gotta take in that language. Y'all gotta speak from public law. That language is so powerful. It's gonna help you go into the next language, which is these treaties and stuff.
Mhm.
Because I got the FAM, the FAM, the Foreign Affairs Manual. I got to understand that because everybody is foreign to each other. And so the Foreign Affairs shows how the United States deal with foreigners. And it's going to show you everything that we're showing you. It's going to show you how the United States presented today. And it's going to show y'all the model instrument and everything. Y'all going to say, hell no. They're going to show you how to break free.
With the Foreign Affairs Manual?
Yeah. Once you understand the difference between a person and the people, whatever you read, going to show you how to break free.
That's what it seems like is happening right now in my brain.
What's that, John?
The separation and completely understanding it, seeing it in everything that I read. Every time I, open the computer and look at something, it's popping out at me. So that when I'm, looking at these different words and so on and so forth, it's showing me who it's talking about.
And then to see that shit
Yeah.
similar to Constance.
Yeah.
Talking about you, shit. You're talking about all of us.
Word, and what hat we wearing.
Yeah.
Yeah, yeah. And it's showing you, once you get the mindset of it showing you the separation and how they're trying to sit in your seat, and if you remove them out the way and you sit there and you take on the title, oh my Lord, it shows you your power. So in these securities, they're going to say, you got to go to the commissioner. You got to go to the commissioner. Well, at the end of the day, who's the true commissioner? Your estate.
Yep.
We
I'm
are.
about to say, yeah.
Yeah, so when you go in agreement with yourself, all you're doing is giving the commissioner notice to register your agreement. You can sign it on back to them. Y'all had to learn to consign this stuff back to them. They're public office. They're called public media. Public relations. They're the ones who deal with the public for you. They're your liaison. They're your shield. Oh, hey y'all, I'll give you an experience. So if y'all don't know, I gotta go to court. But it ain't no criminal case. It's bullshit. But in the court experience, when you file something into a case, it looks like an envelope. It looks like a file folder, right? You gotta have a cover letter to get in. So I'm laughing because I'm like, damn, you gotta create a cover letter. Y'all understand that I know how to create a cover letter, so I'm laughing. But me and Mr. Norris has been going over the post, so she's starting to understand the power of the post, right? So I'm sitting there, and I'm wanting to call Mr. Norris so bad to show her what they doing. So now I done created a cover letter, y'all know I got my own damn cover letter. I just put my information on their cover letter.
Mm-hmm.
And then, if you understand the power of customs supersedes everything else, what I'm putting into the file is nothing but my credentials. It ain't nothing but my seal from the state of Georgia and my custom declaration dispatch note, right? So as I scan all this stuff in, and the guy helps me put all this stuff up real fast, I understand what he was doing, but shit, if you're gonna help me, come on. And then I hit send, right? When I hit finish. When I hit finish, y'all, that shit closed up like a letter and gave me a register number. I said, hell no. So now I'm laughing, right? Because they acting as the post office. The damn courthouse acting as the post office. So I'm laughing. So now they got to verify the information before they upload. So the people behind the window looking at my shit, this is the first time they ever got a custom letter. So now they got to follow custom protocol. You got to see how they was back there huddled up talking about my ass.
Could you hear what they were saying?
Nah, I wasn't trying to hear it. I already know. They was like, oh shit, he's an ambassador. He's a foreign ambassador. Oh shit. It take presidents over the whole damn case. So now when they put my cover letter and my information into the system, the judge is sitting there with a damn computer. And what I've learned is he got credentials and all his cases are up under his motherfucking dashboard. So you know how you go on Facebook, you got a dashboard?
Right.
Y'all, that's all this shit is. He got a dashboard. Right? And he's sitting there looking at all his cases, and his cases are in order. So, so all the paperwork that's in front of him ain't nothing but blank instruments, blank templates. He ain't doing nothing but preloading his motherfucking dashboard. I said, look at this shit.
Wow.
I said, oh, God. I said, oh, Lord. So check it out now. So I got to go in there tomorrow. So you know when he hits that case, it's going to show the importance of the custom declaration dispatch note. It's going to alert him of the authority. So he's going to know off the rip without me even saying that. So when I got back to the house, I go to checking over all my emails and stuff. Y'all, guess who emailed me?
The judge.
Who emailed you?
The damn cover letter. I emailed myself, talking to myself the whole damn time with the computer. I said, oh, shit. The computer responded back to my cover letter. Hell no. Y'all, they're not doing nothing. The computer is programmed to talk back to your ass. The computer is programmed to give you the response based on the information you give it. I'm sitting there talking to my damn self. I said, oh, shit.
Huh.
It responded back and called me first. It responded back and called me an ambassador and Ferdinand and everything.
Wow.
I said, God is good. The computer act just like God. You get a quick response. And all they had to do is hit yay and nay, like the Bible says, for acceptance or refusal. They hit acceptance and said, Ramos, it's accepted. You can leave. They got my ass out of there.
That's
I
crazy.
was like, hell no. Y'all, that was a real neat experience to see how I manually gave them my information, and they had to follow the protocol of customs to upload my information.
Mhm.
So if they would have had a fee, it would have been eliminated. So I got free access to the system. Depositing anything, registering anything with the system, I got free access.
Wow.
I said, look at this. So when you go do deeds and all this stuff, how they charge you, they won't charge me no more.
Mhm.
Because the system will not charge me based on how it received. So they had to put all my information in their system. They had to show my exemptions and my exclusion. They had to show the UPU and the diplomatic relation. It's got to show all this stuff because that's how she received me. That's how it received me. So it responded how it received me. I said, Lord, 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 this stuff is obvious. It is love.
Free state of John's town, I think.
Yeah, there you go. Free state. Yeah,
Jamestown. That's the move.
yeah,
There you go.
yeah.
It's going to show the Confederate and the Union and how
Yeah.
we did a joint resolution on coming together to administrate to the people.
Yeah.
John,
Yep.
yeah, free state of Jones. Yeah, that's it. Yeah, I think it's Jones. I think that might be it.
So in my position, y'all, when I go to court, I don't go to court as a crime no more. It's not a crime when I go to court. I go to court that just closes the case out and move on.
Right. Go to court to administer. Period.
Yeah. Just making sure the case is closed.
Proceeds for them people.
Yeah, all the proceeds is returned back to the estate.
You ain't,
Goodness gracious.
that's kind of like a
Crazy.
special appearance. You know, you showing up
Yeah,
without having to show up.
I show up as a private attorney general.
Mm-hmm.
Because don't the state got a general attorney?
Mm-hmm.
So I show up as a private general attorney.
Without protesting.
Once you say private, they can't do nothing to you. They can't say you practicing law.
Right.
But you got to understand the seat to go in there and talk.
So basically, when you abolish, there's a lot more hats that you got to wear or be acclimated.
Yeah, but I don't have to wear the hat. Just going in there saying you're the ambassador is all. I just like playing the role, so I won't never forget.
Right. I'm like that too. I want to go up in there and see their face and name.
Look, I want God to give me an Oscar. Y'all know what Oscar really mean. Y'all gonna fall out. That's an acronym.
Sure it is. What?
But on the lower level, it's nothing but a corporate binder. It's a dashboard that houses all your awards that you've drawn up and gonna issue. So you giving out Oscars, giving out awards.
Which is your carbons.
Yeah, which is your carbons, which is your letters and parcels. Giving award. Oscar.
Oh man.
Online collection solution. Online. It's OC, right? So
Yeah.
Oh
No, it's OS. OSC.
It's online solution, carbon, analyst, and reporting.
What?
It's nothing but It's nothing but climate control.
Wow.
It's logistics of your postal instruments. It's nothing but it's nothing but your damn corporate binder. That's it. A portfolio of all your awards that you have issued out, or all your securities that you have issued. So yes, I want the creator to give me an Oscar of acting out thy will, not my will.
Mm-hmm.
I want an Oscar from the Most High, not from that.
Oh, that's right. Oh, that's right.
Hey, like you got your high as hell talking about the Lord.
Oh man, that's dope. That is dope.
Y'all gonna get there though. Y'all gonna get there. And a lot of y'all already know this stuff. It's just getting it in order. Having it in order. Boom, boom, boom. Y'all see it as y'all draw it up. Y'all start to see y'all boom, boom, boom. Y'all start seeing that y'all have the keys. And what comes with a piano? It has keys, right?
Yes, sir.
And when you understand how to be in a tune or atonement, that means align with the creator. You be the conductor, the orchestrator. You know how to put a tune together. You'll be in harmony, peace, and joy. You won't sound like racket, like the beginning.
Oh man.
That's all this is.
Yeah, the way you simplify this thing is astronomical. I'm gonna tell you that. It's definitely prolific. You got a way to simplify it right back down to the source, which is the Most High.
Well, honestly, John, I'm gonna be real with you. I had prayed to the Lord, could He help me simplify and modernize this stuff? Because I said this is outrageous of how it's being expressed. And sure enough, soon as like a few days later, I pulled out the damn streamline agreement. I fell out. And when I read the streamline agreement, the first damn thing it says in there to simplify and to modernize. I said, hell no.
Ironically, that's the first document I read. Since
I
I've
did
been on this thing right here.
all that reading, and God said, okay, now here you go to simplify it. But all that reading I needed to do because all those templates that they show you, you start to learn that it's the same templates. So that default is all the templates I'm going to show y'all. It's just the title change. The word change.
Oh, they got this stuff right here for you.
Yeah, and they even give you the templates. And what's funny, they even give you the general form.
Well, you could apply it whichever way necessary.
Yeah, but you gotta understand it. You gotta understand who you are, or you're not even gonna be able to fill out them damn forms that they show you. That's the whole key to understanding who you are.
That's why I said this is a reprogramming process for the most part.
I would like to hear somebody else's thoughts over there. Where that Rafiki stick at? Start popping people. Call them out like the teachers do. Whoever got their names, call them out. They can't make nobody talk, but call their asses out.
Oh man. Y'all, I just got through eating not too long ago, so I'm fighting the itis.
Look, y'all,
listen at the same.
y'all done got him tired of hearing me already. I told y'all better start participating now.
No, you did good, John.
No, we need you more often, John.
Absolutely.
It's past my bedtime. I'm still up, John.
This
I'm
is
definitely on borrowed time.
Mhm. No, what was that? Something went beep, beep. Did y'all hear that?
Yeah, that was somebody's phone.
Oh,
Yeah, that was a message or something. Yeah, I gotta put this girl to bed 'cause she got a doctor's appointment tomorrow.
hey. All right,
do
so
what you gotta do with that baby, Johnny.
yeah.
Listen, man. That's all I do, man. That's my objective at this point.
I understand, brother. I was right there with you. I'm still right there. She 2 years old. My
Yeah.
my fighting ain't over with yet.
So you know exactly what I'm going through. When I was
Pray
supposed
for
to call you back the other, when I was supposed to call you back the other day, she had what I like to call a catastrophe, where it came out the side of the diapers and all this
Oh
other
no.
stuff. And
Oh no.
started putting her hands on it, wiping on the bed. That's why I ain't never make it
Oh.
to call you back because I had to bathe her, change the sheets, all that. I just had to do a bunch of stuff. You know, I don't mind it at all, but come
and
again?
put on the surgery outfit.
Mm-mm.
Yeah, exactly. There you go. By the time got everything situated, I had to put her down. She like, Daddy, I want some milk. I want milk.
It probably tore up
Girl,
like that.
she only drink like a little oatmeal and almond milk though. She ain't on the dairy stuff.
Oh, okay.
Yeah.
Okay, y'all. So, I think we got enough to get those documents started. And when do we want to reconvene?
At your earliest convenience.
2 more days.
Rhonda?
I'm available. I'm burning it at both ends.
Okay.
I missed the consultation today, but I made it. I'll make it up on Friday. No big deal.
Okay.
We
Okay.
do what we gotta do.
All right.
2 more days.
2 more days. Okay.
Yeah, yeah, because they need to do. I just did a fast outline of it. Y'all
Okay.
need to read that stuff for yourself. Even though
Yeah,
y'all need to read it for yourself.
Okay.
definitely need to dig in.
Yeah, I'm gonna reread those documents anyway. I like to read stuff at least 3, 4 times till stuff start popping out at me. But it's the mindset that you go into when you're reading it and the prayers that you ask for before you start. Well,
Okay.
Yeah.
that's for me. That's for me anyway.
I always meditate before I start my paperwork for sure.
Oh, okay.
Okay.
There you
Well,
go.
we'll set up a meeting in what in about 3 days, maybe 4. Give people enough time. Take care of other things that they might need to do. So
Okay.
yeah, 4 days I think should be good. Is that okay with you, Rob?
That's good.
Okay. All right. I know it's past your bedtime.
Ryan in the bed already. He is in the bed. I'm trying to tell
He is.
Okay. I'm gonna
He
stop the
is.
recording now, and then
All right.
once it loads down, then I'll just send it out to everybody.